5. Indirect duty views. No serious moral thinker accepts the view that animals may be treated in just any way we please. All agree that legitimate moral constraints apply to our treatment of them. When we inquire into the grounds of these constraints, however, agreement quickly gives way to conflict, and we are faced with the task of reflectively assessing the adequacy of the competing views. Though the positions examined in this and the following chapter differ in important respects, all share one important feature. Each position affirms or implies that we may adequately account for the wrongs done to animals without having recourse to animal rights. The present chapter begins the task of critically examining the major, but certainly not the only, attempts to dispense with animal rights. 5.1. Indirect and direct duty views. The major options to the rights view, if we might put matters in these terms, fall into two divisions. First, there are what will be termed indirect duty views. Common to these views is the proposition that we have no duties directly to animals. Rather, animals are a sort of medium through which we may either succeed or fail to discharge those direct duties we owe to non-animals, either ourselves, other human beings, or, as on some views, God. We have then, according to these views, duties involving animals, but no duties to them. An example from another quarter might help to make this clearer. It might be held, and some do hold, that we have no duties directly to works of art, say to Picasso's Guernica. Rather, we have, in this case, direct duties to human beings, including future generations of human beings, to preserve and protect the best examples of art presently in our trust. Thus, we do have a duty involving Guernica, but we have no duty to that work itself. The duty to preserve the painting is an indirect duty to humanity. Similarly indirect, then, according to indirect duty views, are our duties involving animals. In the case of rare or endangered species, for example, if we have a duty to preserve them, this is not a duty we owe to the animals themselves, but rather an indirect duty owed, for example, to humanity. We owe it to human beings, both present and future generations, to take the necessary steps to ensure that presently endangered species of animals continue to exist, so that these humans might, say, take pleasure in viewing them or increase their knowledge of the world by studying them. The second major classification of theories at odds with the rights view is what will be termed direct duty views. Like the indirect duty views to be considered, the direct duty views attempt to dispense with appeals to the rights of animals as a ground on which to rest our moral dealings with them. Unlike indirect duty views, however, direct duty views hold that we have duties directly to animals. These views may differ over what direct duties we have, and do differ over why we have those we do. It is thus possible, for example, that two direct duty views might give conflicting accounts of the grounds of our duty to preserve rare or endangered species, while agreeing that the preservation of, say, Siberian tigers is a duty we have directly to these animals, and not a duty owed directly only to humanity or, say, God. Utilitarianism and attempts to ground duties to animals on considerations about cruelty and kindness are the most noteworthy and influential examples of direct duty views. They will be examined in the following chapter. The present chapter is limited to the reflective assessment of representative indirect duty views. 5.2. Moral agents and moral patients. A helpful place to begin is to distinguish between moral agents and moral patients. The former idea was briefly explained earlier in 4.2. Moral agents are individuals who have a variety of sophisticated abilities, including in particular the ability to bring impartial moral principles to bear on the determination of what, all considered, morally ought to be done, and having made this determination, to freely choose or fail to choose to act as morality as they conceive it requires. Because moral agents have these abilities, it is fair to hold them morally accountable for what they do, assuming that the circumstances of their acting as they do in a particular case do not dictate otherwise. If an action is the result of duress, coercion, unavoidable ignorance, or a psychological impairment, for example, temporary insanity, then the individual may fairly be excused from being held responsible for acting as he or she does in those circumstances. In the absence of such excusing conditions, however, moral agents are justly and fairly held accountable for their deeds. Since it is they who ultimately decide what they do, it is also they who must bear the moral responsibility of doing or not doing it. Normal adult human beings are the paradigm individuals believed to be moral agents. To defend this belief would take us far afield from the present inquiry, involving us in debates dealing both with the existence of free will, for example, and with the extent to which we are able to influence how we act by bringing reason to bear on our decision-making. Though it is a large assumption to make, the assumption will be made that normal adult humans are moral agents. To make this assumption in the present case plays no theoretical favorites, since all theories examined in this and the following chapter share this assumption. Now, moral agents not only can do what is right or wrong, they may also be on the receiving end, so to speak, of the right or wrong acts of other moral agents. There is, then, a sort of reciprocity that holds between moral agents. I can do what is right or wrong, and my doing either can affect or involve you, and you can do what is right or wrong, and what you do can affect or involve me. Let us define the notion of the moral community as comprising all those individuals who are of direct moral concern, or, alternatively, as consisting of all those individuals toward whom moral agents have direct duties. Then one possible specification of who belongs to the moral community is that all and only moral agents belong. This is the conception of the moral community common to all indirect duty views. Any individual who is not a moral agent stands outside the scope of direct moral concern on these views, and no moral agent can have any direct duty to such individuals. Any duties involving individuals who are not moral agents are indirect duties to those who are. In contrast to moral agents, moral patients lack the prerequisites that would enable them to control their own behavior in ways that would make them morally accountable for what they do. A moral patient lacks the ability to formulate, let alone bring to bear, moral principles in deliberating about which one among a number of possible acts it would be right or proper to perform. Moral patients, in a word, cannot do what is right, nor can they do what is wrong. Granted, what they do may be detrimental to the welfare of others. They may, for example, bring about acute suffering or even death, and granted, it may be necessary in any given case for moral agents to use force or violence to prevent such harm being done, either in self-defense or in defense of others. But even when a moral patient causes significant harm to another, the moral patient has not done what is wrong. Only moral agents can do what is wrong. Human infants, young children, and the mentally deranged or enfeebled of all ages are paradigm cases of human moral patients. More controversial is whether human fetuses and future generations of human beings qualify as moral patients. It is enough for our purposes, however, that some humans are reasonably viewed in this way. Individuals who are moral patients differ from one another in morally relevant ways. Of particular importance is the distinction between A, those individuals who are conscious and sentient, that is, can experience pleasure and pain, but who lack other mental abilities, and B, those individuals who are conscious, sentient, and possess the other cognitive and volitional abilities discussed in previous chapters. For example, belief and memory. Some animals, for reasons already advanced, belong in Category B. Other animals quite probably belong in Category A. The moral status of these latter animals will be addressed in subsequent chapters. Our primary interest in this and in succeeding chapters concerns the moral status of animals in Category B. When, therefore, the notion of a moral patient is applied to in the discussions that follow, it should be understood as applying to animals in Category B and to those other moral patients like these animals in the relevant respects. That is, those who have desires and beliefs, who perceive, remember, and can act intentionally, who have a sense of the future, including their own future, that is, are self-aware or self-conscious, who have an emotional life, who have a psychophysical identity over time, who have a kind of autonomy, namely preference autonomy, and who have an experiential welfare of the kind clarified in Chapter 3. Some human moral patients satisfy these criteria. For example, young children and those humans who, though they suffer from a variety of mental handicaps and thus fail to qualify as moral agents, possess the abilities just enumerated. Where one draws the line between those humans who have these abilities and those who do not is a difficult question, certainly, and it may be that no exact line can be drawn. On this problem, see 9.4. But how we should approach the question in the case of human beings is the same as how we should approach it in the case of animals. Given any human being, what we shall want to know is whether his or her behavior can be accurately described and parsimoniously explained by making reference to the range of abilities that characterizes animals, desires, beliefs, preferences, etc. To the extent that the case can be made for describing and explaining the behavior of a human being in these terms, to that extent, assuming that we have further reasons for denying that the human in question has the abilities necessary for moral agency, we have reason to regard that human as a moral patient on all fours, so to speak, with animals. As previously claimed, some human beings are moral patients in the relevant sense, and it is only those individuals who are moral patients in this sense, who have, that is, the abilities previously enumerated, whether these individuals be human or non-human, who are being referred to in this chapter and in the sequel when reference is made to moral patients. Moral patients cannot do what is right or wrong, we have said, and in this respect they differ fundamentally from moral agents. But moral patients can be on the receiving end of the right or wrong acts of moral agents, and so in this respect resemble moral agents. A brutal beating administered to a child, for example, is wrong, even if the child herself can do no wrong, just as attending to the basic biological needs of the senile is arguably right, even if a senile person can no longer do what is right. Unlike the case of the relationship that holds between moral agents, then, the relationship that holds between moral agents on the one hand and moral patients on the other is not reciprocal. Moral patients can do nothing right or wrong that affects or involves moral agents, but moral agents can do what is right or wrong in ways that affect or involve moral patients. Now, indirect duty views, we have said, limit the membership of the moral community to all and only moral agents. Thus, moral patients, even paradigm moral patients, children and the mentally enfeebled, are of no direct moral significance. We have no direct duties to them. Rather, if or as we have duties involving moral patients, even human moral patients, these are indirect duties we have to moral agents. It is against this backdrop that we can understand why indirect duty views place animals outside the class of individuals of direct moral concern. They stand outside the boundaries of the moral community because, according to these views, they are moral patients, and because only moral agents, only those who stand in the reciprocal kind of relation in which moral agents stand to one another, are members of this community. This does not mean that there are no moral constraints on what we may do to animals, any more than it means that there are no moral constraints on what we may do to those humans who are moral patients. It is simply to say that the grounds for why we may treat animals in some ways, but not in others, like the grounds for why we may do this in the case of, say, young children, are not to be located in how our actions directly affect them. It is only if or as what we do to them affects moral agents that we can have a moral basis for deciding that some ways of treating animals are permissible while others are not. Indirect duty views, as understood here, are not speciesist, if by that term we understand the attempt to draw moral boundaries solely on the basis of biological considerations. A speciesist position, at least the paradigm of such a position, would take the form of declaring that no animal is a member of the moral community because no animal belongs to the right species, namely Homo sapiens. To deny animals membership in the moral community because they are not moral agents, however, is not to deny them membership solely on the basis of their failing to belong to the right species. It is to deny them membership because they lack the necessary cognitive and other prerequisites that underpin the reciprocal relationship that holds between the only individuals who, according to indirect duty views, are members of the moral community, namely moral agents. That this way of arbitrating who is and who is not of direct moral concern is not speciesist should be abundantly clear once we remind ourselves that some human beings fail to qualify for membership, despite the fact that they are Homo sapiens. There may be other prejudices at work in the attempt to limit membership in the moral community to all and only moral agents, but speciesism, at least in its paradigmatic form, is not one of them. Indirect duty views invite different kinds of criticism, some applying to individual theories, others to all such theories equally. Objections of the latter kind are the most fundamental, but also the most controversial, since they rely on appeals to intuitions in the reflective sense, a procedure that, as we saw in the previous chapter, some philosophers regard as defective. I shall postpone lodging these fundamental objections until after we have examined representative indirect duty views on their individual merits. My initial goal will be to expose the inadequacies of representative indirect duty views without relying on appeals to intuition, or relying on them only when the philosopher whose views are under examination recognizes the legitimacy of doing so. That way, I cannot be charged with stacking the deck against proponents of indirect duty views. Two preliminary points are in order. The first concerns completeness. Certainly there are other indirect duty views besides those examined in the following pages. In terms of the number of theories considered, therefore, my examination must be judged to be incomplete. In terms of the comparative importance of the positions discussed, however, the discussion can lay claim to reasonable completeness, since the positions we are about to examine are the strongest, not the weakest examples of indirect duty views. Second, though much of the discussion that lies ahead is devoted to the moral status of animals, it is not only animals whose moral status is at stake. Human moral patients, like animals in the relevant respects, occupy a position of the same kind as these animals, given indirect duty views. In endeavoring to dismantle these views so that we might come to recognize the direct moral significance of animals, we are also endeavoring to do the same for these human beings. Though some who criticize the concern about the moral status of animals evidently do not realize this, to be for animals is not to be against humans. On the contrary, the refutation of indirect duty views not only goes some way toward ensuring that we think about the moral status of animals properly, it also assists our understanding of the moral status of human moral patients. What one is against is not humanity, but the assumption that some humans, those who are moral agents, have a privileged moral status. To secure a better understanding of why this assumption is arbitrary by itself will not guarantee that either animals or human moral patients will be treated better by moral agents, but it would seem to be a helpful and possibly an essential precondition of making moral progress in our treatment of them. 3 indirect duty views will be examined. These are 1. Rational egoism, as this is set forth by the contemporary Canadian philosopher Jan Narveson. 2. Contractarianism, as this is understood by John Rawls. And 3. Kant's position. We will explore these positions in the order just given and assess each on its merits. Later on in this chapter, an objection fatal to all indirect duty views will be explained and defended. 5.3. Narveson's view. Rational egoism. The position Narveson advocates, which he calls rational egoism, is thought by him to support an indirect duty view. According to this position, every rational being attempts to maximize its utilities, whatever they may be, that is, to satisfy its desires, interests, etc. As a consequence of adopting this stance, according to Narveson, the individual rational egoist sees the need to enter into an agreement with other rational egoists on a set of restrictions on everyone's behavior, because to do so helps the individual egoist maximize his utilities. Narveson would have us believe that this set of restrictions represents what we presently mean by morality. Rights, too, have their basis in self-interest, according to Narveson. To talk of rights, he says, is to talk of the basis of claims which we have self-interested reason to make and do make to varying degrees. As for why other rational egoists should recognize the claims made by an individual egoist, this is, as one might suspect, because it is supposedly in their rational self-interest to do so. They have an interest in our respecting them in their case, an interest which rationally induces them to close the deal, as it were, and commit themselves to paying the price of respecting them in our case. A consequence of Narveson's position is that individuals who are unable to enter into agreements, make self-interested claims, and once having made them, bring appropriate pressure to bear to see that these claims are acknowledged by others, cannot possibly have rights. Now, since animals, according to Narveson, fail to meet these requirements, they fail to qualify as possessors of rights. More than this, Narveson thinks they fail to be directly protected by the restrictions comprising morality. As Narveson states, this perspective, that is, rational egoism, puts animals out of reach of morality without at all denying that they are capable of suffering, etc. Instead, it provides the basis for a frank, and of course heartless, rejection of the relevance of their sufferings. A superficial reading of Narveson suggests he is denying that animals even qualify as moral patients, but some further things he says make it clear that he allows them this status. He notes that there is plenty of room within it, that is, within rational egoism, to argue, say, that we would be better people if we did respect animals, or that animals really are quite lovable and we would do better to treat them as pets than as potential meals, and so on. These remarks, including the unpacking of the and so on, for example, rational egoists might have aesthetic, scientific, sentimental, or ecological interests in animals, make it clear that Narveson is not denying that we have any duties regarding animals, only that we can have any direct duties to them. In itself, the suffering and, more generally, the harm done to animals is of no moral significance. It is only if or as harming them happens to affect our interests that we have a reason, albeit an indirect one, for disapproving of it. Though Narveson is not as clear as one might wish on this score, his account of our duties with respect to animals is in essential respects the same as the account he gives of our duties with respect to humans who, because they lack the right rational equipment, also fail to qualify as rational egoists. The humans in question are young children and mental incompetents of all ages. The duties we have in their case are indirect duties, and Narveson sketches his account of the grounds of our duties involving these moral patients. If we can show that his views regarding human moral patients are deficient, we can reach the same verdict in the case of his views regarding animals like these humans in the relevant respects. That is the main strategy used in the critical argument that follows, but I shall also want to raise other objections along the way. Narveson's reasons for recognizing indirect duties to human children and the mentally enfeebled of all ages are set forth in the following passage. There are reasons of a straightforward kind for extending the ambit of morality to infants and morons, etc. We want to extend it to children because most of us want to have our own children protected, etc., and have really nothing to gain from being permitted to invade the children of others. We have an interest in the children of others being properly cared for because we don't want them growing up criminals or delinquents, etc., and we do want them to be interesting and useful people. And we shall want the feeble-minded generally respected because we ourselves might become so, as well as out of respect for their rational relatives who have a sentimental interest in these cases. How adequate is Narveson's position? Not very. One feature of Narveson's account of egoism, we know, is his belief that not all human beings are capable of entering into the sort of agreements the results of which he would have us identify with the rules of morality. A newly born baby, for example, cannot do so. To enter into such agreements requires a degree of physical, mental, and emotional maturity the very young have yet to reach. At what point exactly a growing child reaches the requisite degree of maturity may well be impossible to say. but it seems safe to assume that a 4-year-old child has not reached it. Narveson advances a number of reasons why the interests of a normal child of this age should be protected. These are given in the longish quote previously. Here, however, let us ask why the interests of a child of this age should be protected if the child happens to be mentally enfeebled, but not so enfeebled that he lacks desires, beliefs, emotions, and the other abilities possessed by animals. One of the reasons Narveson gives is that we ourselves might become mentally enfeebled, and thus we ourselves will have an interest in ensuring that the interests of the mentally enfeebled are protected. But who is this we that Narveson refers to? It can only be rational egoists, those human beings, in other words, who have reached a level of maturity enabling them to determine what is in their self-interest, all considered, and thereby enter into advantageous agreements. Suppose we grant that it would not be in the self-interest of a rational egoist to reach an agreement whereby his interests would not be protected, if he should happen to become mentally enfeebled. Then we can ask whether this fact provides us, as rational egoists, with a reason for protecting the interests of others who are similarly enfeebled. The answer is no, for no rational egoist could possibly be acting in a way that was contrary to his interest in being treated well if he should end up being mentally enfeebled, if he entered into the following agreement, and if we assume that the agreements egoists reach are kept. Human beings who have reached a level of maturity sufficient to reach agreements based upon one's self-interest shall have their interests protected if they subsequently become enfeebled. But this protection shall not be extended to those human beings who are or become enfeebled before they are sufficiently mature to enter into agreements based upon what is in their self-interest. To enter into this agreement cannot possibly be contrary to the rational egoist interest in having his interests protected if he should happen to become enfeebled, and assuming such agreements are honored, since his ability to enter into this agreement ensures that he already is one of those humans whose interests are to be protected by the terms of the agreement. He stands to gain a good deal of insurance, as it were, at very little cost. And the fact that the congenitally enfeebled, for example, stand to lose a great deal need not sway either his reason or his conscience. It need not sway his reason, since there is nothing logically inconsistent, viewed from the perspective of rational egoism, in protecting the interests of those mental incompetents who once were capable of entering into self-interested agreements, while failing to protect the interests of those who never were able to do this. And it need not sway his conscience, since, given that he is an egoist, what he ought to do is just what he is trying to do, namely, reach an agreement that favors maximizing his interests. If, then, rational egoism is to provide a basis for protecting the interests of all mental incompetents, including those born in this condition, the grounds for this protection must be sought in some place other than in the egoist's interest in seeing that he is treated well, that his interests are protected if he should happen to become enfeebled at some later date. This brings us to Narveson's second reason, namely that as rational egoists, we will have reason to protect the interests of children, including those who are mentally enfeebled, because their rational relatives will have a sentimental interest in their being treated well, and it will be in our self-interest generally to be supportive of whatever is required to show respect for this interest of theirs. Besides, a point Narveson does not make but could have, we would want the interests of these moral patients protected if we happen to be related to them, and as rational egoists, we could not expect others to do what we are not ourselves willing to do. This latter reason will be examined simultaneously with the examination of the one Narveson does give. There is a fatal objection to any attempt to ground the protection of the interests of children generally, and the enfeebled in particular, in the sentimental interests of others, which is, after all, what Narveson must do, given the failure of his first reason. Appeal to sentimental interests makes the duty to protect these moral patients wholly contingent upon other beings having and continuing to have a sentimental interest toward them. Where this interest is lacking, there an egoistic basis for this duty will be lacking also. And it is a plain, even if it is a regrettable, matter of fact that this interest not only can be lacking, but sometimes actually is noteworthy for its absence. Suppose Smith has no interest in the life and well-being of a child, to whom he happens to be related. Say he has a mentally impaired son, whom he despises. And suppose Smith would personally gain a great deal if he were to arrange to have his son used as a subject in grossly painful trivial research. What argument can the proponent of egoism give as to why Smith should not volunteer his son, or, if it is in my self-interest to help Smith close the deal, why I should not assist him? Will he say that to be a party to such grossly immoral conduct cannot possibly be in one's self-interest? Then he is naive. The gears of right conduct are not so finely meshed with those of self-interest that we cannot profit personally by doing what is wrong. Will he say that it is human nature to have a sentimental interest in the life and well-being of our children, and thus that the sort of case imagined never can occur? Then he flies in the face of the harsh realities of human existence. Even in the case of so-called normal children, not a few are unwanted, unloved, uncared for. The case of the impaired is no different. Will he say, then, that, though this much is true, still one can never be certain it will be to one's advantage to permit children to be treated in ways that harm them? Then he underestimates human cunning and sagacity. Occasions can and do arise where one can be as certain as one can be in such matters that harming children, or allowing others to do so, will maximize one's utilities. Assuming that neither Smith nor I have any sentimental interest toward his son, assuming that to allow him to be harmed would be to our advantage, and recognizing, as argued above, that Narvison's first reason fails to provide a rational basis for protecting the interests of mentally impaired children, then it follows, given the tenets of Narvison's version of egoism, that neither Smith nor I have a duty to protect the interests of his son. Perhaps it will be objected that no moral theory can itself ensure that people will do what is right and avoid doing what is wrong, something which, it might be alleged, the preceding objection assumes. However, this would be to misunderstand the force of what has been argued. What has been argued is that Narvison's attempt to ground our indirect duties to the mentally enfeebled, duties he recognizes and attempts to account for, is rationally defective. It is not that his theory fails to do what no theory should be required to do, namely ensure that everyone does what is right and avoids doing what is wrong. Rather, his theory fails to give a satisfactory account of our duties involving mentally enfeebled humans, considered on its own merits, that is, even assuming that these duties are indirect duties. The same kind of argument can be given against attempts to ground duties to normal children in the sentimental interests of others. There are further problems with a Narvisonian attempt to reduce morality to the dictates of rational egoism, however, problems concerning what his theory could allow in the case of the treatment of moral agents. On Narvison's view, what agreements a given rational egoist should strike with others is contingent on what the former judges to be in his, presumably long-term, self-interest. Imagine such an egoist who happens to have the benefits of wealth, leisure, education, access to the best medical care, and the other goods that characterize upper middle-class existence. Suppose most other rational egoists are similarly advantaged, while a small minority lack these benefits and live in abject poverty. And suppose, finally, that the majority judges that, all considered, the following sort of agreements would serve their interests best. Policies are to be instituted favoring their retention of wealth, access to an education, and the like, while denying these benefits to the minority of egoists who presently lack them. A rigid class or caste system is agreed upon, including the necessary social and legal machinery to further the ends of the advantaged by keeping the disadvantaged in their place. Now, one might question whether such an arrangement could truly be in the long-term self-interest of those rational egoists who now happen to be advantaged. However, there is no reason why this is impossible, even granting that those who are presently advantaged would have to pay a certain price in terms of their security because, for example, a revolt on the part of the disadvantaged is always a possibility. And the advantaged will also have to give up some portion of their time and wealth to ensure that a trained and loyal cadre of lawyers, law enforcement officers, and legislators effectively protect the interests of the advantaged rational egoists. Despite these costs, it remains possible, all considered, that such agreements will be in the self-interest of each advantaged rational egoist and judged to be so by each. the implications of such agreements must surely offend our sense of justice. Although social and political arrangements that favor the interests of the advantaged over the disadvantaged perhaps are not unjust in all cases, social and political arrangements designed with the overriding purpose of favoring the advantaged while denying others opportunities to secure the benefits the advantaged enjoy, for example, wealth and proper medical care, are paradigms of social and political injustice. They arbitrarily discriminate against some in order to further the interests of others, and so present us with grossly inequitable, unjust social and political institutions. That a given moral position implies that such arrangements are morally permissible provides the grounds for lodging a most serious moral objection against it. Narveson's version of rational egoism does imply this. As an advantaged rational egoist, my decision to enter into agreements with other rational egoists, as well as what agreements to make, can only be decided on the basis of what is, or what I judge to be, in my self-interest. That being so, no compelling reason can be offered as to why I might not limit my agreements to those rational egoists who happen to be similarly advantaged, agreeing with them on the desirability of keeping a given minority of other rational egoists in their present disadvantaged position, and, as a consequence, also agreeing on the desirability of instituting the necessary repressive measures to accomplish this end. Rational egoism, then, at least in the form we find it sketched by Narveson, has unacceptable implications, even if we limit our attention to the implications of that position to how moral agents may be treated. An account of morality that not only fails adequately to accommodate those human moral patients who are not rational egoists, but also fails to ensure the equitable treatment of those humans who are, cannot be a satisfactory theory of morality all considered. Neither, then, can it be a satisfactory basis on which to leave out animals. The most obvious reply to this last objection, and to the earlier criticisms of his views on our duties involving impaired humans, is not available to Narveson. The reply is that our intuitions about what is wrong or unjust should play no role in assessing the adequacy of moral theories. Though some philosophers take this stance, Narveson is not one of them. He is generally sympathetic to the appeal to our intuitions, believing that our intuitions provide us with a reasonable place from which to start our theory construction and a tenable touchstone against which to test a theory once constructed. That much conceded, it follows that Narveson neither would nor could dispute the propriety of assessing his own theory in terms of how well it conforms with these intuitions. Finding that it fails to conform, he should recognize that its failure in this regard is a serious defect. 5.4. Rawls's position. Contractarianism. The final objection raised against Narveson's version of rational egoism involves recognizing that advantaged rational egoists could agree on arrangements that unfairly redound to their favor, giving them unjust access to certain benefits, for example, wealth or leisure, while denying access to others. Suppose, however, that we imagine that the rational egoists we are concerned with are not persons in the ordinary world. We might imagine them as disembodied persons existing beyond or before the world comes to be. Imagine, further, that the task they have before them is to choose principles of justice that will govern the basic institutions of society, into which they will someday be incarnated. And imagine, finally, that while in their disembodied state, these persons do not know any particular facts about what they will be like when they are incarnated. Unlike Narveson's rational egoists, this new breed of rational egoists do not know whether they will be, say, black or white, male or female, rich or poor, when the time falls due for them to be born into the society whose basic principles of justice they must select. They do not even know when they will be born, though they do know that the society in which they will one day be citizens will be materially prosperous. Lacking as these rational egoists would be concerning their own eventual possession of the various benefits and limitations that would enhance or detract from their own individual welfare, they could hardly be in a position to do what Narvesonian rational egoists can. The latter can select social and political arrangements that will unfairly further their interests over the equal interests of others who are not presently advantaged. This new breed of rational egoist cannot do this. Since they do not know any particular fact about what they will be like, these rational egoists simply are not in a position to choose principles of justice that arbitrarily favor those who are rich, say, over those who are poor, if they are to act in a self-interested way. Indeed, since they do not know whether they will be rich or poor, it can hardly be wise for them to choose principles favoring members of the one class over those of the other. Thus, this way of viewing rational egoists seems to be immune to the final objection raised against Narvison's version of rational egoism. Those familiar with John Rawls' A Theory of Justice will recognize that the imaginary situation described in the previous paragraph provides one way of interpreting what Rawls refers to as the original position, and goes some way toward suggesting why Rawls introduces this heuristic device. Underlying Rawls' approach to a general theory of justice is the necessity that the very selection of principles of justice must ensure impartiality. If we allow those who select the principles of justice to know that they will be, say, white educated males of the leisured class, then given that they are to choose these principles on the basis of what is most likely to further their own interests, the principles they should choose are those that will further the members of that particular group. If, however, operating from behind a veil of ignorance, the individuals in the original position do not know any particular facts about their subsequent identity, they cannot be in a position to select principles that arbitrarily favor their particular interests. Thus is the veil of ignorance intended to ensure an impartial basis for selecting the basic principles of justice. The requirement that those in the original position be ignorant of any particular fact about their future identity also extends to their ignorance of how they will fare with respect to the natural lottery. For all they know, they may be born beautiful or ugly, intellectually gifted or moronic, graced by athletic talents or physically handicapped. Since individuals have not done anything to deserve the natural abilities, or lack of them, with which they come into the world, possession or non-possession of such abilities cannot provide a just basis on which to select the basic principles of justice. Ignorance of how each individual will fare with respect to the possession of these abilities to ensure impartiality must be included in what these individuals do not know when, operating from behind the veil of ignorance, they select these principles. Among the things they do know, on Rawls' view, is that they will at some time be a member of the society concerning whose basic principles of justice they are deciding, and that, as future members of this society, they will be human beings. One would think, given the preceding, that the principles of justice selected by those in the original position would apply, and direct duties of justice would be owed, to all human beings, both human moral agents and human moral patients. In fact, however, Rawls evidently thinks otherwise. In an essay that predates A Theory of Justice, Rawls explicitly limits those to whom direct duties of justice are owed to moral agents. It is, he writes, a necessary and sufficient condition to qualify as an object of direct duties of justice that one be capable to a certain minimum degree of a sense of justice. One must, that is, understand what justice is and be able to bring considerations of justice to bear on one's deliberations and act accordingly, at least to a minimum degree, if one is to be owed duties of justice. Or to put the same point in terms already previously explained, one must be a moral agent to be owed duties of justice by other moral agents. Because not all human beings are moral agents, or persons in Rawls' sense, it follows, given the views expressed by Rawls in this earlier essay, that not all human beings are owed duties of justice. In A Theory of Justice, Rawls says some things that suggest that he backs away from this earlier position. Most significant in this respect is his claim that he has not maintained that the capacity for a sense of justice, or what comes to the same thing on the interpretation advanced here, the capacity for moral agency, is necessary to be owed duties of justice. But this claim must be squared with what Rawls then goes on to say about individuals who lack the sense of justice. It does seem, he writes, that we are not required to give strict justice to creatures lacking this capacity. As Edward Johnson, a philosopher at the University of New Orleans, notes in his critical discussion of Rawls, this is puzzling. Although possession of a sense of justice is not necessary to be owed justice, we are nevertheless not required to give strict justice anyway to creatures lacking this capacity. What then? Loose justice? Or no justice at all? The suspicion is that what Rawls takes back with one breath, he reaffirms with the next. For it can only seem that we do not owe strict duties of justice to creatures lacking the capacity for a sense of justice, if it seems that having this capacity is a necessary condition of being owed these duties. Thus, though the Rawls of A Theory of Justice, unlike the Rawls of the earlier essay, refrains from explicitly maintaining that having this capacity is necessary for being owed duties of justice, the available evidence indicates that he remains enamored of this view. This suspicion gains additional support when we note that in A Theory of Justice, Rawls states that the only contingency which is decisive that is regarding who is owed direct duties of justice, is that of having or not having the capacity for a sense of justice. But if this is the only contingency that is decisive, then having this capacity cannot be viewed merely as a sufficient condition of being owed these duties. It must also be viewed as necessary as well. Despite some wavering on Rawls's part, therefore, it would not be implausible to interpret him as continuing to suppose that having the capacity for a sense of justice or for moral agency is both a necessary and sufficient condition of being the sort of individual to whom duties of justice are owed. Because Rawls is not unequivocal on this important matter, fairness and caution dictate that we distinguish between two positions he might hold, a strong one and a weak one. The strong position is that being a moral agent is a necessary and sufficient condition of being owed duties of justice. The weak position is that being a moral agent is a sufficient condition, but that it only seems that it is necessary. On either position, the implications for animals, as they exist in the actual world, are not very promising. Since animals are not moral agents, the strong position implies that we have no duties of justice to them, while the weak position implies that it seems that we do not. Neither position, it will be argued in what follows, is consistent with Rawls's own account of what he calls natural duties, and both rest on an arbitrary denial of the direct moral significance of animals and those humans like them in their relevant respects when it comes to questions of justice. Before turning to these matters, however, there is a further problem of interpretation that requires our attention. In Rawls's view, neither the weak nor the strong position characterized above entails that we have no duties regarding moral patients, including animals. What Rawls fails to make clear is whether those duties we have regarding animals are direct or indirect duties. It is therefore unclear whether Rawls should be included among the proponents of indirect duty views. Reasons will be advanced in what follows, however, that show that Rawls is committed to a view of this kind if his overall position, as he understands it, is to be consistent. In order to show this, I will initially assume that the duty not to be cruel is supposed by him to be a direct duty. Then it will be shown that this would render his overall position inconsistent, again as he understands it. After this has been shown, I will then go on to diagnose the source of the arbitrariness that infects Rawls' view of the moral status of moral patients generally, and of animals in particular. After having noted in A Theory of Justice that it does seem that we are not required to give strict justice to creatures who are not moral agents, Rawls goes on to state the following. It does not follow that there are no requirements at all in regard to them, that is, animals. Certainly it is wrong to be cruel to animals, and the destruction of a whole species can be a great evil. Thus, though animals are not moral agents and so are not owed, or at least it seems that they are not owed, strict justice, we do have duties in their case, including in particular the duty not to be cruel to them. If we assume, for the present, that this latter duty is a duty we have directly to animals, then Rawls's position comes to this. We have some direct duties to animals, despite the fact that they are not moral agents, that is, persons. But we do not have a duty of justice to them, or at least it seems that we do not. This difference between those to whom we owe the duty of justice on the one hand and those to whom we owe the duty not to be cruel on the other is at odds with what Rawls says about these duties elsewhere in A Theory of Justice. In section 19 of that work, Principles for Individuals, the Natural Duties, Rawls offers two characteristics of what he calls natural duties. First, they apply to us without regard to our voluntary acts. And second, they hold between persons irrespective of their institutional arrangements, obtaining between all as equal moral persons. The first characteristic distinguishes natural duties from those duties, such as the duty to keep a promise, that arise as a result of the performance of a voluntary act. The second distinguishes natural duties from those we have as a result of our occupying a given place in an institutional arrangement, such as the duty of an employee to an employer. Rawls lists examples of natural duties. Of particular importance for present purposes is that the list includes both the natural duty not to be cruel and the duty of justice. The dilemma Rawls must face should already be apparent. Natural duties, he says, hold between persons, between all as equal moral persons. But animals are not persons, which is why we are not required, or at least it does not seem that we are not required, to give strict justice to them. If, however, both the duty not to be cruel and the duty of justice are natural duties, if natural duties hold equally between all persons, and if the fact that animals are not persons casts doubt upon or undermines our having the natural duty of justice to them, then the fact that animals are not persons should also cast doubt upon or undermine our having the natural duty not to be cruel to them. Yet Rawls allows that we have a duty not to be cruel to animals. If, however, the fact that animals are not persons does not by itself show or raise the suspicion that we do not have the natural duty against being cruel to animals, then this same fact cannot by itself show or raise the suspicion that we do not have the natural duty of justice to them. Yet Rawls denies that we have the duty of justice to them, the strong position, or affirms that it at least seems that we do not, the weak position. The dilemma that Rawls must face, then, is that he simply cannot have it both ways. Either being a person is a decisive consideration for determining those to whom we have, or seem to have, natural duties, in which case he cannot believe that we have a direct duty to animals not to be cruel to them, or being a person is not a decisive consideration, in which case he cannot advocate either his strong or his weak position regarding animals and the duty of justice. Whichever alternative Rawls should choose, it must be one or the other, not both. Two replies that seek to diffuse this dilemma are worth considering. First, it might be objected that the duty of justice can only obtain between individuals who can have this duty to each other, and that this is a relevant difference between this duty and the duty not to be cruel. In the case of this latter duty, this objection holds. We have it to animals despite the fact that they do not have it or any other duty to us. In the case of the duty of justice, however, we do not have it to animals because they cannot have this duty to us. This reply goes no way toward defending a disanalogous understanding of the two natural duties in question. What one wants is an explanation of why the fact that animals cannot owe the duty of justice rules out their being owed this duty, or at least seems to. If the fact that they cannot owe the duty not to be cruel does not rule out, or seem to rule out, their being owed that duty. The objection just sketched fails to provide such an explanation, and it is difficult to imagine what such an explanation might look like. What might appear to be the two most promising kinds of explanation are not available to Rawls, given his analysis of natural duties. We cannot say that we have no duty of justice to animals because they stand outside certain actual political or other types of institutional arrangements. Natural duties do not depend for their binding force on such arrangements. Nor can we say that we have no duty of justice to animals because we have not ourselves, as actual persons, in the actual world, entered into any agreement with them. Natural duties do not depend for their existence on the performance or non-performance of any voluntary act on the part of anyone in the actual world. This much granted, it should be clear that no appeal to our acts or our institutions can provide grounds for disenfranchising animals when it comes to the natural duty of justice or to any other natural duty. The second reply ignores the contingencies of the actual world and refers instead to the hypothetical situation of the original position. Animals are owed the duty against being cruel, but not the duty of justice according to this second reply, because this is the judgment that would be reached by those in the original position. After all, since the original contractors are self-interested persons who know they will be human beings when they are incarnated in the actual world, they will view the duty of justice in a way that is calculated to forward their self-interest as the human beings they know they will become. Thus, to exclude animals from those to whom the duty of justice is owed can hardly be contrary to the self-interest of the original contractors. This objection merits two replies at this juncture. First, appeals to the agreements reached by those in the original position, agreements which supposedly affirm that we have the natural duty not to be cruel to animals, but deny that we have the natural duty of justice to them. Such appeals simply fail to address the dilemma posed earlier. Whatever agreements they reach, the original contractors must at least be consistent regarding the grounds they have for reaching them, and they cannot be consistent in this regard if, without citing any relevant difference, they affirm that being a person is a decisive consideration for determining who is owed one natural duty, justice, but deny that being a person is a decisive consideration for determining who is owed another natural duty, the duty not to be cruel. Since mere appeals to the hypothetical agreements of those in the original position fail to cite, let alone defend, a relevant difference regarding the scope of the two natural duties in question, such appeals provide no escape from the dilemma raised against Rawls. Second, if following Rawls, we assume that those in the original position know that they will be human beings when they are incarnated in the actual world, we need to ask what possible basis the original contractors can have for agreeing that the natural duty not to be cruel includes a direct duty not to be cruel to animals. The duties these contractors will recognize must be contingent upon what duties are in their self-interest to recognize. But if, ex hypothesi, those in the original position will never become animals and know this, then they cannot possibly have any self-interested reason to recognize a direct duty not to be cruel to animals, a duty that is owed directly to animals independently of human interests. Thus, if the duty not to be cruel is a natural duty, which is what Rawls says it is, and if we have this duty directly to animals, which is what we are assuming he believes, then the grounds for our having this duty directly to animals are not to be found by asking about the supposed outcome of a hypothetical agreement struck between the self-interested persons in the original position. A contract including direct duties to animals cannot be forthcoming if the only basis for selecting duties is the yardstick of human interest. In view of the two objections raised against the second reply, therefore, Rawls cannot be spared the pain of the dilemma urged against him by having recourse to what does or does not transpire in the original position. The dilemma posed above thus seems recalcitrant to attempts to amputate or dull its horns if the duty not to be cruel to animals is viewed by Rawls as the duty we have directly to animals. This dilemma can be avoided, however, if Rawls views this duty as an indirect duty. It is not clear that he does view this duty in this way. At one point in A Theory of Justice, Rawls states that the capacity for feelings of pleasure and pain and for the forms of life of which animals are capable clearly impose some duties on us, including the duty not to be cruel to them. A natural interpretation of this claim is that these facts themselves about animals impose certain duties on us, in which case the duties these facts impose would seem to be direct duties we have to animals themselves. Now, it may be that Rawls wants to view some duties regarding animals in this way, that is, as direct duties. For reasons already adduced, however, he cannot do this except at the price of rendering his position, as he understands it, inconsistent. If we assume, then, that when faced with the choice between 1. Abandoning his weak or strong positions concerning justice in animals on the one hand, or 2. Abandoning his presumed view that at least some duties regarding animals are direct duties on the other, Rawls would select the option that is least damaging to his overall position as he understands it. Then it's not unreasonable to suppose that he would choose the second alternative. Were Rawls to make this choice, one might concede that he at least has an apparently consistent position when it comes to our duties regarding animals and other moral patients. But serious questions remain concerning the adequacy of his position. To begin with, Rawls' exclusion of human moral patients from the class whose members are owed the duty of justice results from his failure to distinguish clearly between 1. The abilities necessary if one is to be able to select between alternative principles of justice, and 2. The abilities necessary if one is to be owed duties of justice. Rawls is certainly correct in believing that those individuals in the original position who are called upon to select principles of justice must have a sense of justice and a conception of their own good as expressed in an overall life plan, though each is ignorant of the specific details of the actual plan they will have when they come to be in the actual world. Even granting this, it does not follow that only moral agents are owed duties of justice, or even that this seems to be so. Indeed, not only does this not follow, but there are ample reasons to believe that those in the original position would have self-interested reasons for denying this. For consider, those in the original position do not know how they will fare as a result of the natural lottery when they are incarnated. For all they know, they may turn out to be human moral patients when they come to be, despite the fact that in their pre-incarnated condition, they have the abilities of moral agents. If we assume that those in the original position select principles of justice with a view of what will be in their self-interest after they have been incarnated, they would do well to select principles that recognize a direct duty of justice to human moral patients. Not to do so would be to run the serious risk of not having one's interests adequately protected in one's incarnated state, if one turns out to be, say, a moron. Moreover, those in the original position will be children if they are born humans, whether normal or otherwise, at some point in their life. Rather than permit the protection morality will afford them in their youth to be contingent upon the sentimental interests of their elders, as, for example, on Narvison's view they would be, a sensible contractor would select principles imposing duties of justice even in the case of how these humans should be treated. While those who select these principles must have a sense of justice, those who are owed duties of justice need not. A sufficient condition of being owed such duties is that one have a welfare, that one be the experiencing subject of a life that fares well or ill for one as an individual, independently of whether one also has a conception of what that is. To recognize this condition as sufficient would be an eminently reasonable position for anyone who, operating as a self-interested contractor from behind the veil of ignorance, was called upon to select principles of justice and to decide who is owed duties of justice. It is only if we allow those in the original position knowledge that they will be human moral agents, not human moral patients, that they could have self-interested reason to affirm that duties of justice are owed to the former, but not the latter. But the veil of ignorance, if it is to ensure impartiality in the selection of principles of justice, including who is covered by these principles, will not allow this knowledge. Once we recognize that those in the original position would have self-interested reasons to require that human moral patients are owed duties of justice, we will also see that animals like these humans in the relevant respects cannot be non-arbitrarily excluded from being owed these same duties. The only apparent reason the original contractors could have for judging the case of animals differently is if we assume, as Rawls does, that those in the original position know that they will be human beings, whether agents or patients. But this is to prejudice the case against recognizing duties of justice to animals from the start. To allow those in the original position to know what species they will belong to is to allow them knowledge no different in kind from allowing them to know what race or sex they will be. If knowledge of these latter details must be excluded by the veil of ignorance in order to ensure fair procedure in the selection of principles of justice, then knowledge of the former detail must be excluded as well. The veil of ignorance cannot be thick enough if, while denying access to many of the particular contingencies of one's life, because knowledge of them might prejudice one's selection of principles of justice, it nevertheless allows one to know that one will belong to the species Homo sapiens. The fact that on Rawls's understanding of his theory, animals are not, or at least it seems that they are not, owed strict justice should hardly be surprising. The cards as dealt in the original position are stacked against them. Perhaps it will be objected that the supposition that any person in the original position could become a non-human animal would render the very point of the original position incoherent, since persons in that position are being asked to choose basic principles of justice, principles which, among other things, are to lay the foundation of social and political institutions that will govern the distribution of harms and benefits to those who can meaningfully be said to be beneficiaries in their own right. Animals can be excluded from consideration. Whatever else we might want to say about animals, it might be claimed, they cannot have a good life, and thus cannot be beneficiaries in the relevant sense. To deny that they are owed duties of justice thus is not arbitrary. This response has a point up to a point. It is doubtful at best that we can reasonably view, say, grasshoppers or fleas as themselves either having or not having a life that is better or worse for them, considered as individuals. However, the situation with respect to other animals is importantly different. The case has been made for regarding mammalian animals in particular as being conscious and sentient, as having desires or preferences that may either be satisfied or frustrated, as having various higher-order cognitive capacities, including memory and the ability to form beliefs, including beliefs relating to their own future, as agents in the world, in the sense that they can act intentionally in pursuit of the satisfaction of their desires or preferences, and as individuals who have a psychophysical identity over time. In the case of these animals, therefore, it makes perfectly good sense to view them as having an individual welfare, as faring well or ill during the course of their experimental life, logically independently of whether anyone else happens to value what happens to them. These animals thus can have a good life relative to their nature, and thus can be beneficiaries in the relevant sense, even if it is true that because of their limited intellectual capacities, they themselves are unable to form a conception of their long-term welfare, or have a sense of justice, or have categorical desires, or adopt a rational life plan. Accordingly, assuming that the principles of justice to be selected by those in the original position concern, among other things, the distribution of those harms and benefits essential to an individual's having a good life, the selection would exclude only some animals from being owed duties of justice. Normal mammalian animals 1 year of age or older would, or at least should, be covered by the principles that are chosen. The charge of arbitrariness has not been met. In reply, perhaps it will be objected that it is not justice but metaphysics that excludes even these animals from being owed duties of justice. To suppose that a person in the original position could be incarnated as a dog or chimpanzee, it might be claimed, is to violate standard metaphysical views about identity. Metaphysically, a dog or a chimpanzee just can't be the same individual as one who once occupied a place in the original position. It is not arbitrary to exclude animals from being owed duties of justice, therefore, it could be argued, since even the original contractors may be permitted to know metaphysical truths, including the truth that whatever else might transpire in the actual world when they are incarnated, they simply can't turn out to be a non-human animal. As remarked at the outset of Chapter 3, problems of identity are admittedly serious problems, But their seriousness cuts both ways in the present case. If it is true, as Rawls presumably would allow, that any given person in the original position might turn out to be a human idiot or worse when he comes to be in the actual world, and still be the same individual he was in the original position, then the possession of the central characteristic definitive of moral personality, a sense of justice, cannot be a criterion of personal identity. That being so, what reason can there be against a person in the original position being incarnated as a dog or chimpanzee? It would be a palpable double standard to affirm that a human idiot is the same individual as one of the persons in the original position, despite the fact that, as an idiot, he lacks a sense of justice. But to deny that a dog or chimpanzee can be the same individual as one of the persons in the original position because, given their cognitive and moral poverty, these animals lack a sense of justice. Moreover, to attempt to avoid this display of arbitrariness by supposing that persons in the original position just know that they will be human beings, however handicapped, begs the question rather than answering it. For the question at issue is how animals can be non-arbitrarily excluded from those who are owed duties of justice. To attempt to avoid the point of this question by assuming that the original contractors just know what species they will belong to when they are incarnated is to repeat the problem rather than to resolve it. The charge that the veil of ignorance arbitrarily allows those in the original position to know what species they will belong to has not been met. We may summarize and conclude our examination of Rawls's account of our duties regarding animals as follows. For Rawls to deny that we have a natural duty of justice directly to animals, or to allow that it seems that we do not, conflicts with his view that we have a duty not to be cruel to animals, assuming that this duty is a natural duty owed directly to animals. Rawls could escape this inconsistency by claiming that all our duties regarding animals, including even the duty not to be cruel to them, are indirect duties, and he could advance a similar position in the case of our duties regarding human moral patients, who are relevantly like these animals. But though his position would be consistent at this level if he were to advocate an indirect duty view, it is not adequate in other respects. In particular, the approach Rawls relies on as a vehicle for determining who is owed direct duties, the agreements that would be reached by self-interested contractors in the hypothetical original position, would or should yield the result that human moral patients who have an experiential welfare are owed the direct duty of justice, since it would be in the self-interest of the original contractors to ensure that their interests be protected by justice should these contractors turn out to be human moral patients in the actual world, as in the case of children they will. However, once this much is acknowledged, the question arises concerning how non-human animals who have an experiential welfare can non-arbitrarily be denied being owed this same duty. To allow the original contractors to know that they will be human beings is to prejudice the deliberations in favor of human beings and should be excluded by the veil of ignorance. To attempt to meet this objection by denying that persons in the original position could become animals on the grounds that this contravenes metaphysical laws about identity is demonstrably at odds with what Rawls himself implies about identity. Thus, even were we to grant that by advancing an indirect duty view, Rawls's position is consistent, thereby passing one test that any adequate moral theory must pass, we would still have principled reasons for denying that it passes another crucial test, namely, that of impartiality. Rawls's exclusion of animals from the class of individuals who are owed duties of justice is consistent, if it is, only because the grounds for excluding them are arbitrary. Since no ethical theory can be the most reasonable one, all considered, if it is demonstrably arbitrary, to be satisfied with Rawls's theory, despite its many other merits, would be to be satisfied with less than the best. That it requires, if it is to be consistent, that our duties regarding animals are indirect duties is one of its central weaknesses, rather than one of its cardinal strengths. 5.5. Kant's position: humanity as end in itself. Unlike Rawls, whose considered views on our duties regarding animals are unclear at best, Kant provides us with an explicit statement of an indirect duty view. That Kant should hold such a view should not be surprising. It is a direct consequence of his moral theory, the main outlines of which may be briefly, albeit crudely, summarized for a second time. On Kant's view, rational beings, by which he means moral agents, are ends in themselves, have, that is, independent value or worth in their own right, quite apart from how useful they happen to be to others. As such, no moral agent is ever to be treated merely as a means. This is not to say that we may never make use of the skills or services of moral agents in their capacities as, say, mechanics, plumbers, or surgeons. It is to say that we must never impose our will by force, coercion, or deceit on any moral agent to do what we want them to do just because we stand to benefit as a result. To treat moral agents in this way is to treat them as if they had no value in their own right, or alternatively, as if they were things. As Kant remarks, beings whose existence depends not on our will but on nature have nonetheless, if they are non-rational, only a relative value and are consequently called things. Moral agents are not non-rational, do not have only a relative value, and are not things. Moral agents, rational beings, are ends in themselves. What Kant calls the categorical imperative is, he believes, the correct principle for determining how imperfect rational beings ought to treat themselves or one another. In the case of my interactions with other moral agents, what the categorical imperative requires of me, as was noted in the earlier characterization of Kant's views, is that I never make an exception for myself by acting on reasons I could not will that every other rational being could act on. For example, I cannot make a deceitful promise, hoping to benefit from the deceit, and universalize my reasons, what Kant calls my subjective maxim, since if all moral agents were to do what I aspire to do, then no one would believe such promises when they were made. If I were to universalize the exception, making a deceitful promise, I would destroy the rule, the making of reliable promises. Thus, I am unable to universalize my reasons for making my deceitful promise, and thus it is wrong to make it. To ensure that I do not do what is wrong, I must abide by the first formulation of the categorical imperative, the formula of universal law. I ought never to act except in such a way that I can also will that my maxim should become a universal law. The immorality of making a deceitful promise also can be illuminated, Kant thinks, by viewing it against the backdrop of the kind of value moral agents possess. As was mentioned earlier, the worth of rational beings does not rule out the permissibility of making use of their skills or services. It does rule out treating them as if they had no value over and above the use we can make of them. This is something I am guilty of, for example, whenever I withhold information from moral agents that is relevant to their making a rational judgment, because I stand to gain from their ignorance. For example, if I were to promise Anne that I will return the money I want to borrow from her, but withheld from her my intention not to repay, then I would be keeping from her information that is relevant to her making a rational judgment about whether to lend me the money. And I do this because I stand to be the beneficiary of her ignorance. Were she to know of my intention never to repay, she probably would not lend. In this way, then, I treat Anne as if she had value merely as a means relative to my goals or purposes, as if she were a mere thing. To treat her in this way, Kant believes, is wrong. For we are always, he writes, to treat humanity, both in our own person and in the person of every other, always as an end, never as a means merely. This, the second formulation Kant gives of the categorical imperative, is referred to as the formula of end in itself. Kant believes that the two formulations of the categorical imperative given in the above are equivalent. He is committed to thinking this because he believes that there is only one supreme principle of morality, not several. He believes that any act whose maxim fails to pass the test of universalizability, the formula of universal law, also fails the test of end in itself, and vice versa, and that acts whose maxims pass the former test also pass the latter, and vice versa. There is no act, he thinks, that passes or fails one of the tests without also passing or failing the other. This assumed equivalence between the two formulations of the categorical imperative will occupy our attention at the conclusion of our discussion of Kant's position. Kant's understanding of the foundation of morality, unlike Narveson's and Rawls's, is not egoistic. We are not to imagine that morality arises from, or consists in abiding by, agreements, contracts, reached by rational, self-interested individuals, because it is in their long-term self-interest to do so. Indeed, for Kant, to view morality as grounded in self-interest is to leach the very lifeblood from it. What morality presupposes, on his view, is that, independently of any consideration of self-gain, individual moral agents can do what is right because it is the right thing to do. It is only when individuals do their duty because it is their duty that what they do has moral worth. To suppose, as Narveson and Rawls do, that the basis of morality is self-interest is to destroy the very possibility of morality, as Kant understands this. Moreover, though on Kant's view moral agents do stand in a relationship of reciprocity, in the sense that the fundamental direct duty I have to any moral agent is the very same duty that any moral agent has to me, the obligatoriness of my treating you with respect as benefits your independent value is not contingent upon your treating me in a reciprocal way. The direct duties I have to you would not evaporate or diminish if you failed to fulfill your duties as they affect me, or vice versa. Such failure on your part to fulfill your duties to me, which would destroy the very foundation of our moral relations given a view like Narveson's, would not cause the slightest tremor given Kant's view. Since I am not a participant in the moral game, so to speak, because of what I stand to gain by playing, the rules are not rescinded or eased by your behaving in ways that flaunt them and harm me. For my part, I must continue to act as morality requires, out of respect for what is right, not with a view to my self-interest. While Kant's moral theory is not a version of egoism, it has affinities with the rational egoism of Narveson and the contractarianism of Rawls when it comes to specifying those individuals to whom one has direct duties. On the rational egoism model, these are, as we know, those individuals, and only those individuals, who are themselves capable of entering into the agreements that are chosen to mutually regulate the behavior of individual rational egoists. Moral patients in general, and animals in particular, are excluded. The same is true, though for different reasons, given Kant's position. Moral agents have direct duties only to moral agents, whether themselves or others. This is so, on Kant's view, because beings who exist but are non-rational have only a relative value, and thus fail to be ends in themselves. Because they fail to have independent value, we have no direct duty to them, to treat them in accordance with the formula of end in itself, in those ways we are duty-bound to treat those beings, rational beings, moral agents, who are ends in themselves. If we have duties to non-rational beings, they must be indirect duties, or duties having an indirect bearing on our discharging those duties we have directly to moral agents, ourselves or others. We should expect, therefore, that when he turns to the question of our duties involving animals, Kant would opt for an indirect duty view. Anything more than this would simply fly in the face of his considered views on the nature and foundation of morality. This is an expectation Kant fulfills. So far as animals are concerned, he writes, we have no direct duties. Animals are not self-conscious and are there merely as a means to an end. That end is man. Our duties to animals are merely indirect duties to mankind. Animal nature has analogies to human nature, and by doing our duties to animals in respect of manifestations of human nature, we indirectly do our duties to humanity. Thus, if a dog has served his master long and faithfully, his service, on the analogy of human service, deserves reward. And when the dog is grown too old to serve, his master ought to keep him until he dies. Such action helps to support us in our duties toward human beings, where they are bounden duties. If, then, any acts of animals are analogous to human acts and spring from the same principles, we have duties towards the animals because thus we cultivate the corresponding duties towards human beings. If a man shoots his dog because the animal is no longer capable of service, he does not fail in his duty to the dog, for the dog cannot judge. But his act is inhuman and damages in himself that humanity which it is his duty to show towards mankind. If he is not to stifle his human feelings, he must practice kindness towards animals, for he who is cruel to animals becomes hard also in his dealings with men. Whereas tender feelings towards dumb animals develop humane feelings towards mankind. 3 preliminary criticisms are worth making before moving on to assess Kant's general account of our duties involving animals. First, Kant is mistaken when he claims that animals are not self-conscious. Arguments have been advanced earlier that make ascriptions of self-consciousness to animals both intelligible and confirmable. Second, on one interpretation of what it means to judge, it is false that a dog, and by implication similar animals, cannot judge. If to judge that something is a bone requires A, having even our concept of a bone, and B, applying that concept in a given case, that is, judging, believing, that is a bone, then it is false, for reasons given in Chapter 2, that animals cannot judge. If instead Kant has some other kind of judgment in mind, in particular if he means that animals cannot make moral judgments by making reference to the categorical imperative, then what he says is doubtless true. The same is true of moral patience generally, however, so that Kant cannot disqualify animals as objects of direct moral concern because they cannot make moral judgments, unless he also is willing to disqualify all moral patience. And to disqualify human moral patience, as will be argued in a moment, will cause serious problems indeed for Kant's general position. Third, in the passage just quoted, Kant fails to support his assertion that animals exist merely as a means to an end, that end being man. And it is difficult to see how he could provide a compelling argument in this regard. The plausibility of viewing animals as having value only if or as they serve human ends lessens as we begin to recognize that, like relevantly similar humans, animals have a life of their own that fares better or worse for them, logically independently of their utility value for others. It is thus exceedingly unclear how it could be correct to suppose that their value is reducible, without remainder, to their utility to mankind, unless one is willing to make the same judgment in the case of humans like these animals in the relevant respects, which Kant is not. This line of argument will be developed more fully momentarily. These matters to one side, what shall we say of Kant's general account of our duties involving animals? Despite well-known exceptions, some Nazis practiced great kindness to animals, Kant's general psychological point may be right. People who are indifferent to the suffering they cause animals may come in time to form a habit of indifference, and thus might be equally indifferent to the suffering they visit upon humans, while those who are sensitive in their dealings with animals may develop a habit of sensitivity that is also expressed in their dealings with humans. The point certainly is arguable, and some noted champions of better treatment for animals, George Bernard Shaw, for example, would seem to rest their unqualified opposition to the use of animals in science on a position like Kant's in the relative respects. We must, Shaw writes, apply the test of character and ask ourselves not merely, what will happen if I do this particular experiment, but what sort of man will I be if I do it? In Shaw's view, as in Kant's, it is the effects that our treating animals in certain ways has upon our character, and for Kant, and perhaps for Shaw as well, the effect our character has on how we treat human beings, that provide the grounds for morally approving or disapproving our treating animals in certain ways. The contemporary English philosophers Alexander Brodie and Elizabeth M. Pybus dispute Kant's position on two counts, neither of which contests the accuracy of Kant's psychological speculation. A variation of Kant's psychological argument will be offered in different contexts in 9.1 and 9.4. They argue, first, that Kant's position is radically at odds with a sound, ordinary view concerning our treatment of animals, namely the view that animals, insofar as they have a capacity for suffering, are objects of direct moral concern. And second, that Kant's view regarding our duties involving animals leads to absurdity and is internally inconsistent with other principles in his ethical theory. Though the former criticism is well-founded, it is doubtful that the latter criticism is. The reasons Brodie and Pybus marshal in support of their second criticism are as follows. Kant's argument, put briefly, is to the effect that if human beings maltreat animals, they will acquire a tendency to use rationality, in themselves or in other people, as a means. But, according to Kant, animals are, in the technical sense, things, and consequently are precisely what we should use as means. His argument, therefore, is that if we use certain things, namely animals, as means, we will be led to use human beings as means. Something has gone wrong here. Kant never maintains that it is wrong to use animals as means. For example, as beasts of burden. What he does maintain is that the maltreatment of animals is wrong because it leads those who do so to treat persons in a similar way. And it is clear that Kant does not suppose, as in the passage just quoted Brodie and Pybus erroneously assume that he does, that the concept of maltreating an animal on the one hand and the concept of using an animal as a means on the other are the same or logically equivalent concepts. For we can, given Kant's views, use an animal as a means without at the same time necessarily maltreating it, as when, for example, a blind man uses a seeing eye dog but treats him with love and devotion. This same error underlies the charge of absurdity and inconsistency that the authors level against Kant in bringing their argument to a head. They write, "Thus, if Kant is to use the argument that using animals as means will lead us to use rationality as means, he must generalize it, and say that because of the effect on our behavior towards other people, we ought never to use anything as a means, and we have an indirect duty not to do so. This is not merely absurd, but contrary to his imperative of skill." The point is, however, that Kant does not maintain that using animals as means will lead to the effects in question. What he does maintain is that maltreating them will. So Brodie and Pybus cannot argue that Kant's position leads to the absurd consequence that we have an indirect duty not to use anything as a means on the ground that Kant holds that we have an indirect duty not to use animals in this way. Nor can they say that his view here is inconsistent with his imperative of skill. For what follows from what Kant says is not that we have an indirect duty not to use anything as a means. What follows is that we have an indirect duty not to maltreat anything, if, by doing so, we are led to use the rationality in ourselves or in others merely as a means. Brodie and Pybus have a reply to this attempted defense of Kant. For Kant, they write, whatever is not an end in itself cannot be an object of direct moral concern. But Kant holds that animals are not ends in themselves. If, therefore, we are to speak as Kant wishes of maltreating an animal, we are to speak of maltreating something which is not an object of direct moral concern. Now, maltreatment is a moral concept, insofar as it refers to a mode of dealing with objects which is unfitting to their nature. But if animals are not objects of direct moral concern, then in what can maltreatment of them consist? The inference we are to make is that Kant's position will not allow him to give an account of how animals may be maltreated. But is this true? It would seem not. The issue, it bears emphasizing, is not whether Kant provides us with an acceptable account of how animals may be treated. It is whether his ethical theory allows for the possibility of his presenting any account at all. It seems that it does. What Kant could argue is that maltreatment of those things that have value merely as means consists in treating them in ways that reduce their value as means, which, given the sort of value they have, is unfitting to their nature. And he could then argue that since things have value merely as means, no moral wrong is thereby done to them when they are treated in ways that are unfitting to their nature. Rather, the explanation of when, and if so, why maltreating things is morally wrong is that this will, in time, lead moral agents to maltreat individuals who exist as ends in themselves. An example might make this clearer. An angry child who breaks his art supplies does not destroy something that exists as an end in itself. He destroys something that has value as a means. Now, the supplies which have value merely as means have been treated in a way that is unfitting to their nature as things to be used for painting. But no moral wrong is thereby done to them. The child violates no direct duty owed to the supplies. It does not follow, however, that we either would or must view his conduct as morally indifferent, or that we cannot follow Kant's lead in attempting to explain why his behavior should be nipped in the bud. After all, one ought not to let one's emotions get the best of one, not only because this will lead one to do some foolish things in a fit of rage, for example, destroy art supplies one will later regret not having, but also because a repetition of such behavior could, in time, lead one to lash out in morally offensive ways toward those individuals toward whom one does have direct duties. Needlessly to destroy something that has value merely as a means, arguably, is to treat that thing in a way that is unfitting to its nature. But the moral grounds for objecting to such destruction could be viewed as distinctly Kantian in flavor. Despite objections to the contrary, therefore, Kant can have a consistent position regarding the maltreatment of things having value merely as a means. This much granted, it is a small step, given his view of animals, to see that his position regarding their maltreatment also is consistent with the general principles of his ethical theory. This is because animals are, in Kant's view, as Brody and Pybus note, things, and have only a relative value. As things, then, we maltreat animals when we treat them in ways that reduce their value as means for those individuals for whom, in Kant's view, they exist in the first place, human beings. To treat animals in ways that diminish their utility for us is indeed to treat them in ways unfitting to their nature, given Kant's view, since their nature is to exist as means to our purposes. But the grounds Kant has, and those he can consistently have, for objecting to the maltreatment of animals are not that acting in this way is contrary to any direct duty we have to them. Rather, as in the analogous case regarding the gratuitous destruction of the art supplies, the grounds he has and can consistently have lie in the supposed effects this will have on our character, and thus, in his view, on how in time the habit of treating animals cruelly will lead us to fail to fulfill our direct duties to those to whom we have such duties, namely ourselves and other human beings. To defend the internal consistency of Kant's position, given his assumptions, is one thing. To defend its adequacy is quite another. That position cannot be any more adequate than the assumption that animals are things, and, relatedly, that they have value merely as a means to an end, that end being man. The assumption that animals are things is false at best. For reasons given in Chapter 3, it is reasonable to view animals as having a welfare that is not logically tied to their use by humans to promote human ends. Moreover, while it is admittedly true that animals lack the kind of autonomy required for moral agency, it is false that they lack autonomy in any sense. For animals not only have preferences, they can also act on their own to satisfy these preferences. To view them, as Kant does, as, like art supplies, things, and thus as having, as art supplies have, value only relative to human desires and purposes, is radically to distort what animals are. Even were we to concede, contrary to Brody and Pybus, that Kant's position is consistent, it does not follow that we should view it as adequate. That Kant's assumptions are ill-founded may perhaps be shown more clearly by considering the moral status of human moral patients, given his assumptions. By definition, human moral patients are not moral agents, and so, on Kant's principles, are not rational beings. Because they are not rational beings, they can have no value in their own right, and must instead be viewed as things, having value merely as a means to an end. It follows from this that we can do no direct moral wrong to any human moral patient. All that can be said about our moral dealings with such humans is that our duties involving them are indirect duties to rational beings. Thus, I do no moral wrong to a child if I torture her for hours on end. The moral grounds for objecting to what I do must be looked for elsewhere, namely in the effects doing this will have on my character, causing me, so Kant's view supposes, to become hard in my dealings with human moral agents. But suppose I torture only one human moral patient in my life. Though I am squeamish at first, suppose I steel myself against my usual sensitivities and use all my imagination to visit horror upon the child. And suppose that, having satisfied myself of what I had supposed might be true, namely that I have no taste for torture, I release my captive and never again indulge in torturing any human being again. The habit of cruelty finds no permanent home in my breast. Are we to say that, therefore, I did nothing wrong to my one and only torture victim? However implausible this must seem, Kant's position does imply that the correct answer is affirmative. But Kant's position is worse than implausible. It is arbitrary. Let us suppose, for the sake of argument, that as a result of the pleasure I take in causing human moral patients to suffer, I come in time to develop sadistic habits, and that these in turn lead me to cause human moral agents to suffer. It would be quite remarkable, to say the least, if doing the one led me to do the other, if there was no resemblance between how the two reacted to what I did to them. If, for example, putting human moral patients on the rack produced no behavioral evidence that this hurt them, then how could I reasonably infer that doing this to human moral agents would produce the suffering which, as a sadist, I enjoy inflicting? In order for the causal story to be at all plausible, we must suppose that human moral patients, like human moral agents, can suffer and that they can manifest their anguish behaviorally in ways that resemble the ways human moral agents behave when they are made to suffer. If their behavior is similar, however, as it must be if I am to be led from causing the one to suffer to causing the other to suffer, it is reasonable to believe that their suffering also is similar. But if the suffering is similar, and if causing it in the case of moral agents violates a direct duty owed to them, as Kant allows, then how can we non-arbitrarily avoid the conclusion that causing suffering to human moral patients violates a direct duty owed to them? To reply that moral agents can act in accordance with the categorical imperative, while human moral patients cannot, is true but irrelevant. The issue concerns their shared capacity for suffering, not their differing abilities. If the duty not to cause moral agents gratuitous suffering is a duty owed directly to them, the same must be true of the duty not to do the same to human moral patients. Otherwise, we flaunt the requirement of formal justice. We allow dissimilar treatment of relevantly similar cases. Kant's position does violate this requirement, and the violation of it, as we shall see more fully in a moment, is an unavoidable consequence of the moral arbitrariness of his theory. A defender of Kant might object that Kant has been misinterpreted. It is, he holds, for humanity generally, not just for human moral agents, that things having value merely as a means, including animals, exist. Thus, all human beings, not just those who are moral agents, exist as ends in themselves, on his view, and the argument of the last paragraph is exposed as unfounded. Now, it may be that Kant thinks that all human beings, including human moral patients, exist as ends in themselves, but he cannot consistently think this. For since human moral patients lack the rational prerequisites for moral agency, they can have only a relative value, and must therefore, given Kant's understanding of these matters, be viewed as things. This attempted defense of Kant misfires, therefore, and only serves to sharpen the dilemma he must face. He must choose between viewing human moral patience as ends in themselves, so that being a moral agent is not a necessary, though it may be a sufficient, condition of being an end in itself, or viewing these humans as having only a relative value as things. If he chooses the former option, then we can have direct duties to human moral patience. If he chooses the latter, we cannot. Neither alternative is salutary for Kant. If the former is chosen, then he is obliged to surrender a central tenet of his ethical theory, namely that only rational beings, that is, only those who are moral agents, exist as ends in themselves. If the latter alternative is chosen, he is open to the charge of moral arbitrariness. Though neither alternative is welcome news for Kantians, the selection of the non-arbitrary one has good sense and reason on its side. Human moral patients are not things. They themselves are individuals who have an experiential welfare. Moral agency is not a necessary condition of being of direct moral concern. But logic plays no favorites. This same condition cannot be necessary in the case of other moral patients. If human moral patients are owed direct duties, so are those animals like them in their relevant respects. To deny that we have direct duties to those animals who have an experiential welfare, but to affirm this in the case of human moral patients, like these animals in the relevant respects, would be symptomatic of an unsupported and unsupportable speciesist understanding of morality. One final point, one that plumbs the depths of Kant's arbitrariness, merits our attention before moving on. As remarked earlier, Kant offers what he regards as alternative, equivalent formulations of the categorical imperative. Any act that passes the test of universal law also passes the test of end in itself, and vice versa, and any act that fails the one also fails the other. This can be shown to be false. Suppose I am considering whether to be a vegetarian, not out of considerations that relate to my health, but because I think that the intensive rearing of farm animals is wrong, and is wrong because of how the animals are treated. If I make use of the formula of universal law, there is no reason why I cannot universalize the relevant subjective maxim. No one is to support the intensive rearing of farm animals by purchasing meat from these sources. But now suppose I consult the formula of end in itself. That formula instructs me always to treat humanity, either in my own person or in the person of any other, always as an end, never as a means merely. But how am I to assess the morality of my moral objections to factory farming by reference to that formulation of the categorical imperative? Since the beings I am concerned about are not human beings, that formula provides me with no possible guidance. But if it provides me with no possible guidance, then the two formulae, that of universal law and end in itself, are not equivalent after all. For though my subjective maxim about not supporting the intensive rearing of animals passes the test of universal law, the morality of supporting the intensive rearing of animals cannot even be tested by, let alone pass, the formula of the end in itself. The moral arbitrariness characterizing Kant's position thus makes its presence felt at the most fundamental level, at the level of his interpretation of the fundamental principle of morality. Only undefended prejudice could lead Kant to suppose that an expansive formulation of the fundamental principle of morality, that of universal law, one that allows us to test directly our maxims with regard to how animals may be treated, is equivalent to a restrictive formulation, that of end in itself, one that has no direct bearing on questions relating to how animals may be treated. To limit the direct scope of the supreme principle of morality to how humans are to be treated arbitrarily favors these individuals as it arbitrarily excludes others. 5.6. The moral arbitrariness of all indirect duty views. In the past 3 sections, we have considered representative indirect duty views and found them wanting, usually for reasons peculiar to the particular position under examination. For example, the inequality just noted between Kant's two formulations of the categorical imperative. A common theme that emerged in the discussions of all three positions, however, was that of moral arbitrariness, and it will be useful in this final section to develop the theme more fully, both with a view to bringing our examination of indirect duty views to a close, and as a way of preparing for our examination of direct duty views in the next chapter. The argument about to be developed involves making appeals to our intuitions. We know that this procedure is philosophically controversial, which is why the preceding discussions of representative indirect duty views included some criticisms of each view that did not involve such appeals. If these appeals are allowed, however, not only can we contest those indirect duty views we find in Narveson, Rawls, and Kant by making such appeals, and we have contested each in places by making them, we can also mount an argument fatal to any indirect duty view. This is the argument to which we shall now direct our attention. A suitable place to begin is with Ross's observation that if we think we ought to behave in a certain way to animals, it is out of consideration primarily for their feelings that we ought to behave so. We do not think of them as a practicing ground for virtue. What Ross says here could be enlarged upon to include all moral patients like animals in the relevant respects. That is, individuals who have beliefs, desires, memory, psychophysical identity, a welfare, etc. Neither young children nor the enfeebled, for example, are a practicing ground for moral agents in their pursuit of virtue. If we think it wrong to treat these humans in certain ways, we think this primarily out of consideration for, here we depart from Ross's way of putting the point, their welfare. Both these human beings and animals, Ross implies, are of direct moral concern and are owed some direct duties. Ross certainly seems to be correct in his description of what some people think about the moral status of animals, and, by implication, about humans like these animals in the relevant respects. The problem is, this evidently is not what everyone thinks. In particular, it evidently is not what those who subscribe to indirect duty views believe. To treat any moral patient well or ill, these views imply, is not to discharge any duty we have directly to that individual. And while it may be an exaggeration to say that how we treat moral patients is, on these views, merely a sort of moral warm-up for the really serious moral game played among moral agents, indirect duty views are committed to regarding how we treat moral patients as of no direct moral significance. But the question is not just who thinks what about the moral status of moral patients. The question is, which of the alternatives before us, the view that moral patients are of direct moral significance or the view that they are not, is the most reasonable view? This is a question Ross's description of what we think, considered by itself, fails to answer. Because many, perhaps even most, people happen to think that we have some direct duties to moral patients, it does not follow that we do. Our pre-reflective intuitions do not wear their reasonableness on their sleeve. But while the reasonableness of our pre-reflective belief in the present case is not guaranteed just by the fact that we have it, reasons can be adduced in support of its claim to our considered assent. The procedure for testing our pre-reflective intuitions, sketched in the previous chapter, is relevant here. It is to be assumed that we commit ourselves to making a conscientious effort to reach the best judgment we can, and we do this by striving to think about our pre-reflective beliefs impartially and coolly, against the backdrop of having as much relevant information as we can reasonably acquire, and mindful of the need to think rationally and consistently. We then reflectively review our intuitions with a view to determining which, if any, can withstand the heat of this process of critical assessment. If we make this effort in the present case, the following beliefs can be seen to have the necessary credentials to qualify as considered beliefs. It is wrong, other things being equal, to kill a moral agent, to make moral agents suffer, to deny moral agents access to opportunities for the satisfaction of their desires when it is in their interest to satisfy them. For example, opportunities to secure basic physical health or access to the acquisition of skills, an education, or needed legal counsel. Now, these beliefs, and others besides, share an important feature. They all involve prohibitions against harming moral agents. For harms, as was argued in an earlier chapter, may take the form of inflictions or deprivations that diminish an individual's welfare, either by causing that individual gratuitous suffering, as is true of harms that are inflictions, or by denying that individual opportunities to satisfy desires or fulfill purposes that contribute to her welfare. Because these beliefs share this common feature, it is possible to articulate a general principle, the harm principle, that unifies them. This principle states that we have a direct prima facie duty not to harm individuals. To say that we have a direct duty means that we owe it to those individuals themselves, who fall within the scope of this principle, not to harm them. While to say that the duty is prima facie means that though this duty may be overridden in some cases, for example in self-defense, the burden of showing why and how it may be justifiably overridden must be borne by those who override it. When and how this principle can be overridden are issues explored at length in a later chapter. At this juncture, our interest lies in exploring how extensive the scope of the harm principle is, in particular whether it applies to all and only moral agents. This cannot be what we believe if we share Ross's pre-reflective intuitions. If we share them, we believe that we have a prima facie direct duty not to cause moral patients to suffer or to cause them harm in other ways, and that the reason this is wrong is because of the harm done to these individuals, not because of how others, for example, interested relatives of children or pet owners, will feel about the harm done. Those who accept indirect duty views must think that our intuitions are mistaken. How might we rationally adjudicate this disagreement? To begin with, if advocates of indirect duty views could show that moral patients cannot be harmed, then our intuitions, not their views, would have to be abandoned. Certainly, we could not rationally hold that the harm principle applies to our moral dealings with certain individuals if these individuals cannot be harmed in the first place. However, the case has been made in Chapter 3 that animals not only can be, they are harmed when, for example, they are caused gratuitous suffering, or are denied the opportunity to exercise their preference autonomy when it is in their interests to do so. Thus, this attempt to overturn our pre-reflective intuitions about the prima facie direct duty owed to these animals and to those humans like these animals in the relevant respects fails. In reply, it might be objected that, though moral patients can be harmed, their harm is never equal to the harm caused to moral agents. To deny moral agents opportunities for the exercise of their liberties, or to kill them, is to cause far more grievous harm, it might be claimed, than to deny moral patients the opportunity to exercise their preference autonomy or to kill them. Thus, it is a mistake to view the moral status of moral patients as being equal to that of moral agents. The duty not to harm is a duty owed directly to moral agents. Because the moral status of moral agents and patients is not equal, this duty is an indirect duty in the case of moral patients. This reply embodies an important confusion. The question at issue is not whether, say, killing a moral agent and a moral patient are, other things being equal, equally harmful. The question is whether we have any direct duties to moral patients. This question is logically distinct from the question about the comparative magnitude of harming a moral agent in a given way, on the one hand, and harming a moral patient in a similar way, on the other. For it may be true that harming either is directly wrong, and yet the wrong done when we do some things to a moral agent, for example, kill one, is a greater harm than the harm done when we do the same to a moral patient. Just because my harming you in one way, say I lock you in a closet for 2 days, is, though wrong, less wrong than my harming you in another way, say I torture you to death over a period of many weeks, it does not follow that only in the latter case do I violate a direct duty I have to you. The comparative harm done by 2 acts does not settle anything whatever about whether the duties I violate in the 2 cases are direct or indirect duties. That is the truth the reply under discussion fails to recognize. The issue of the magnitude of harms done to moral agents and patients is explored more fully in 8.10. A different objection to the view that we have direct duties to moral patients does not deny that moral patients can be harmed, but denies that they can ever be harmed in the same ways as moral agents. Individuals who are moral agents, this objection holds, can be harmed by denying them opportunities for advanced education, or by denying them an equal voice in the affairs of their government. Moral patients cannot be harmed in these ways. Thus, this objection concludes the harms done to moral agents are wrongs done directly to them, but the harms done to moral patients are not, and the duties in the former case are direct duties, but those in the latter are indirect. This defense is right up to a point. Because of our higher-order intellectual and other abilities, we who are moral agents can be harmed in ways moral patients cannot be. But both can be harmed in similar ways. To deny either a moral agent or a moral patient basic nutritional sustenance, or to inflict gratuitous suffering on either, or to bring about either's untimely death is to harm the one just as surely as it is to harm the other. While granting that some of the ways moral agents can be harmed are peculiar to moral agents, we are right to insist that some of the ways they can be harmed are common to moral patients. When these common harms are at issue, to affirm that we have a direct duty to moral agents not to harm them, but deny this in the case of moral patients, is to flaunt the requirement of formal justice or impartiality, requiring, as it does, that similar cases be treated dissimilarly. And that is to fall far short of making an ideal moral judgment. In view of the failure of the arguments for the opposite conclusion and assuming that no better arguments are in the offing, we are justified in maintaining that the harm principle's scope includes animals and those human moral patients like these animals in the relevant respects. There is no non-arbitrary way to narrow the scope of this principle to exclude moral patients. Accordingly, even were we not to share Ross's pre-reflective intuitions regarding these moral patients, even were we initially of the opinion that we have no direct duty to these moral patients not to harm them, critical reflection of the sort we have just engaged in would require us to change our opinion if we are to be consistent and if we accept the harm principle. The position favored here, that the duty not to harm moral patients is a duty we owe directly to them, can be strengthened by invoking the requirements of making an ideal moral judgment. Let us consider each in turn. Have we made our assessment of the principle's implications coolly? It is difficult to imagine how the opposite charge could be sustained. No wildly emotional claims have been made. The rhetoric of the passions has not been employed. Throughout, the effort has been made to make the case in a disciplined, non-inflammatory style, that the duty not to harm is a direct duty owed to normal mammalian animals aged 1 year or more, and to those other moral patients like these animals in the relevant respects. So at least one requirement of making an ideal moral judgment has been met. A second requirement is that we be consistent, that we not assert or imply inconsistent propositions. People are not always the best judge of their rational foibles, including their inconsistencies, and so it is perhaps best to await the judgment of others concerning whether any inconsistencies can be detected in the argument of this last section. As an autobiographical remark, however, it is perhaps worth noting that I can neither see nor imagine how the charge of inconsistency could be sustained. A third requirement is impartiality, which I have interpreted in terms of conforming to the principle of formal justice, of treating similar cases similarly. This is a requirement that has not been lost sight of. On the contrary, one common failing of the 3 indirect duty views discussed earlier is that they fail to meet this requirement. Indeed, once we have made the case that moral patients can be harmed, and can be harmed in ways that are in some cases similar to the ways moral agents can be harmed, respect for the requirement of impartiality will require that we make similar judgments about the harmful treatment of both. Understood in context, it is those who deny that we have direct duties to moral patients, not those who affirm this, who are guilty of failing to meet this requirement. Fourth is the requirement of being informed, of having the relevant empirical considerations at hand and understanding them. Ideally, of course, we must have all the relevant empirical matters in tow, and no claim could be made that this ideal has been completely realized by the preceding discussion. Nevertheless, it is essential to note that the empirical considerations relevant to viewing animals as having an experiential welfare have been identified and defended in earlier chapters. These animals, and those human moral patients like them in the relevant respects, are conscious and sentient, have desires and preferences, have various cognitive abilities, including memory and the ability to form beliefs, including beliefs about their own future, are agents in the world in the sense that they can act intentionally or purposively to bring about the satisfaction of their desires or preferences, are self-aware or self-conscious, have a psychophysical identity over time, and so on. The empirical grounds for viewing animals in these ways have been canvassed, and representative arguments challenging these findings have been considered and found wanting. This by itself does not constitute incontrovertible proof of the view of animals favored here, but it is fair to say that the case made for viewing them in this way has been explored in more depth and with greater care than we find in the case of Kant, for example. Though the ideal of complete information has not been fulfilled, it has not gone unnoticed either. The fifth requirement for making an ideal moral judgment is that of relying on a correct or valid moral principle. In the preceding chapter, some of the most important criteria for evaluating moral principles and the theories of which they form a part were sketched, and it will be useful to apply these criteria to the harm principle. The first criterion is that a moral principle cannot be adequate if it is inconsistent. If, in particular, it implies that the very same act can be both right and wrong. The harm principle does not have this implication. To inflict gratuitous suffering on anyone who can suffer, be they moral agent or moral patient, is wrong according to this principle, no matter what morally responsible agent does it, no matter when the act is performed or where. It is not as if, say, doing this while in England is wrong, but doing it in California is quite all right. The second criterion is that of adequate scope. Does the principle in question unify by identifying relevant grounds for a wide range of cases, and may it therefore be appealed to and relied on when we are faced with making decisions in a large number of situations? The wider the scope, the greater the principle's potential use. The harm principle does have considerable scope, applying as it does to how we may treat any moral agent or patient. It does not follow, of course, that it is enough by itself to cover all moral matters, and for reasons offered in subsequent chapters, there are grounds for denying that it does. Having said this, however, it remains true that the harm principle has considerable scope, and so cannot be rejected on the grounds that it is too narrow in its application to be of much use. Precision is the third criterion relevant to assessing moral principles. This is an essential requirement, since unless we are clear on what a moral principle means, we will have no clear way of determining what it requires. The harm principle has that degree of precision it is reasonable to expect and require of a moral principle. The notion of harm has been explained at length, so that anyone who understands that explanation also understands what the principle rules out as prima facie wrong. Granted, the notion of harm is not as precise as ideas we find in, say, geometry, where a square, for example, can be given an exact definition. But morality is not geometry, and it would be unreasonable, as Aristotle implies when he makes his observation about how much precision an educated person would and should expect in different subjects, to demand that the notion of harm be defined with mathematical precision. The last criterion identified was that of conforming with our considered, reflective intuitions. A good deal has been said on this score already. The harm principle unifies by identifying the relevant grounds for a large number of our reflective intuitions. Many of these intuitions involve beliefs about direct duties owed to moral agents. For example, that it is prima facie wrong to kill them or deprive them of their liberty. So to give up the harm principle, to reject it, would leave one with the challenge of trying to find another principle that is equal to or better than the harm principle in the relevant respects. That is, in terms of scope, consistency, precision, and conformity with our reflective intuitions. It is not logically impossible that there might be such a principle, and to claim that, though this is possible, there is no other equally good or better principle would be unjustified at this stage in the argument. At the same time, the onus of proof must be borne by those who think otherwise, since a strong presumptive case has been made that the harm principle meets the relevant criteria for evaluating a moral principle. The challenge of showing that there is another principle that satisfies these criteria to an equal or better extent must be met by those who would deny or replace it. The preceding does not constitute a strict proof of the harm principle, proof of the sort one can give in, say, geometry. But just as it is unreasonable to expect definitions in morality that are as precise as those we find in geometry, it is similarly unreasonable to expect proof of the same kind. This does not mean that we must regard this principle as self-evident. Reasons can be given for accepting it. This is what has been attempted in the present section, to show that the harm principle meets the criteria appropriate for evaluating moral principles, so far as one ever can show this, and to defend, as has been done, the most controversial criterion we have appealed to, namely conformity with our reflective intuitions, is as much as can reasonably be expected. Without having to claim that this principle is self-evident, we have good reasons to accept the harm principle, even though we cannot give, and should not be expected to give, a proof of that principle comparable to proofs in geometry. To have made the case for acceptance of the harm principle, given all that this case involves and implies, is to undermine the credibility of any indirect duty view. The harm principle's scope cannot be non-arbitrarily limited to all and only moral agents. It must apply to all those whose experiential welfare can be adversely affected by harms, whether inflictions or deprivations. Moral agents can be harmed in these ways, and so we have a direct, prima facie duty in their case not to harm them. But animals also can be harmed in these ways, as can human moral patients like these animals in the relevant respects. Thus has the case been made, to the extent any moral case can be made, for acknowledging that we also have a direct prima facie duty in their case not to harm them. To deny this, given the reasonableness of the harm principle, can only be a symptom of moral arbitrariness, since, by definition, all indirect duty views deny that we have any direct duties to moral patients. No indirect duty view can provide us with an adequate moral theory. The theme of arbitrariness that recurred in our earlier discussions of representative indirect duty views thus proves to be illustrative of the moral arbitrariness that must plague them all. The moral arbitrariness of indirect duty views is diagnosed at a deeper level in 8.12. 5.7. Summary and Conclusion. The chapter began by drawing a distinction between direct and indirect duty views. The former hold that at least some of the duties we have involving animals are duties we owe directly to animals. The latter hold that all those duties we have regarding animals are indirect duties owed to others, for example, God. Only indirect duty views were discussed. Such views are not speciesist if the reason for denying direct duties to animals is their failing to be moral agents, since many human beings, for example children and the mentally impaired, also lack this status. Like animals, these humans are moral patients. They can neither do what is right nor what is wrong, but they may be on the receiving end, so to speak, of the right and wrong acts performed by others. Indirect duty views attempt to account for our duties involving moral patients, while denying that we either do or can do anything right or wrong directly to them. Representative indirect duty views were considered and rejected, the rational egoism of Jan Narveson because, among other reasons, it could sanction grossly unjust institutional arrangements between moral agents, the contractarianism of John Rawls, because, among other reasons, those in the original position are arbitrarily allowed to know that they will not be animals when they are incarnated, and Immanuel Kant's respect for humanity, because, among other reasons, it rests on an impoverished understanding of what animals are. The demonstrable arbitrariness of indirect duty views provided a backdrop for identifying a moral principle, the harm principle, that applies to our treatment both of moral agents and moral patients. That principle lays down a prima facie direct duty not to harm any relevantly similar individual who can be harmed. That is, any individual who has beliefs and desires, is capable of acting intentionally, and so forth, and who has an experiential welfare. The case for accepting this principle was made by making reference to its success in meeting the relevant criteria for evaluating moral principles: consistency, adequate scope, precision, and conformity with our reflective intuitions, and by explaining that our judgment of its validity was made, so far as it is reasonable to hope, in compliance with the relevant conditions of an ideal moral judgment: impartiality, rationality, information, and coolness. Though not proven in the way that, say, the Pythagorean theorem can be proven in Euclidean geometry, the arguments given in support of the harm principle provide good reasons for accepting it. Any ethical theory that fails to account for our prima facie direct duty not to harm moral agents and moral patients cannot be an adequate theory, all considered. Necessarily, therefore, no indirect duty view can command our rational assent. Whether any direct duty view passes this test is the central question examined in the chapter that awaits us.